In a move that has shocked the nation, the United States Supreme Court made a historic decision this week, one that will undoubtedly reshape the landscape of constitutional law and police accountability. A unanimous 9-0 ruling, a rare event in the court's history, sends a powerful message. The law has gone too far off track, and it's time to make a change. To understand the significance of this, we need to recognize just how rare this level of agreement is among the Supreme Court justices. In a court often divided along ideological lines, a unanimous decision is almost unheard of. Yet, this ruling was so crucial that even the most polarized court in modern history came together to address a matter that transcends party lines, police conduct, and Fourth Amendment rights. The case at hand involved a deeply troubling practice that had persisted for years, one that allowed police officers to justify the use of force based on a narrow, momentary perception of threat, the moment of threat doctrine. This doctrine had allowed officers to escape accountability for actions that led to unnecessary harm and, in some cases, death. But now, in a 9-0 decision, the court has declared that enough is enough. The law can no longer be interpreted in a way that selectively protects rights based on geography or based on a momentary perception of danger. The Fourth Amendment, which guarantees the right to be free from unreasonable searches and seizures, must be applied consistently across the country. This ruling is not just a legal victory, it's a wake-up call to lawmakers, police officers, and citizens alike. It signals a fundamental shift in how the law will protect citizens and hold officers accountable. The court has shown us that constitutional rights are not regional, and no one's rights should be subject to the whims of where they live or who they encounter in law enforcement. This ruling marks the death of the moment of threat doctrine. And while it may seem like just another case, it has opened the door to a more just system, one where the rights of citizens are not decided by geography, but by the full context of a situation. Now, I encourage you to subscribe to stay up to date with this incredible shift in American law. The story doesn't end here. The impact of this ruling will continue to unfold, and you won't want to miss what comes next. Stick with us as we dive deeper into the details of this monumental decision and what it means for the future of police accountability and your constitutional rights. In the wake of this groundbreaking ruling, we find ourselves confronting a deep, unsettling truth. The application of constitutional rights in the United States has never been as consistent as we might have hoped. For years, Americans have assumed that their constitutional protections were universal, guaranteed equally, no matter where they live. Yet, this assumption has been shattered. In fact, it has become glaringly apparent that your rights under the Constitution could be affected by the very zip code you live in, the federal circuit court that hears your case, and even the political climate of your region. Across the country, the application of the Fourth Amendment, specifically the protection against unreasonable searches and seizures, has not been consistent. In some places, federal courts have followed a well-established approach that examines the totality of the circumstances, evaluating the entire context of a police encounter. This approach looks at the officer's behavior, the circumstances leading up to the use of force, and whether any alternative actions could have been taken. It's a balanced, fair system that aligns with the founding principles of the Constitution. However, in other parts of the country, a different rule was in place, a rule so narrow it bordered on absurdity. Under the moment of threat doctrine, courts disregarded everything that happened before the final moments of an incident. All that mattered was whether the officer perceived a threat in the final seconds of the encounter. This narrow lens effectively ignored the context of the situation, including whether the officer's own actions had escalated the situation in the first place. The result was a fragmented system where the same constitutional right could be interpreted in completely different ways depending on your location. This, of course, is deeply problematic. This lack of uniformity has led to significant injustice. In some regions, citizens could count on their Fourth Amendment protections being upheld. In others, they were left vulnerable to unchecked police power. This inconsistency has eroded trust in the legal system and led to widespread uncertainty about what rights individuals actually have. Now, with the court's intervention, there is hope for a more consistent and fair application of the Constitution, a future where rights are guaranteed equally, no matter where you live. The moment of threat doctrine is a deeply controversial legal standard that has shaped the way police use force in the United States. Under this doctrine, judges were instructed to focus solely on the final moments of an encounter between law enforcement and a suspect. Specifically, they would ask, was there a perceived threat in the final few seconds before force was used? If the answer was yes, the officer's actions were deemed reasonable, often resulting in the dismissal of cases before they even reached a trial. This narrow lens for evaluating police conduct ignores the broader context of a situation, including the actions leading up to the moment force was applied. It disregards whether the officer's own decisions escalated the situation, whether safer alternatives existed, or if de-escalation was possible. The result is a legal system that fails to hold officers accountable for their decisions and tactics throughout an entire encounter. In effect, it allows police officers to justify excessive force by focusing only on the moment when they felt threatened, regardless of the actions that led to that perception. The core flaw in this doctrine lies in its myopic focus. It simplifies complex interactions between police and citizens into a single, isolated moment, ignoring the buildup that may have triggered that moment in the first place. This approach has allowed police to sidestep accountability for actions that, while deemed necessary in the final seconds, may have been reckless or unnecessary earlier in the encounter. The issue is not just about a split-second decision, but about the context that led to it. In the case of Ashton Barnes, for example, the actions of Deputy Constable Roberto Felix were not given proper scrutiny. The decision to jump onto Barnes's moving car, a maneuver widely discouraged by police training, was seen as irrelevant under the moment of threat doctrine. The focus remained solely on whether Felix perceived a threat at the time he fired. This legal framework had serious consequences, often leading to tragic outcomes with no trial, no jury, and no accountability for the officer involved. In the past, the application of constitutional rights in the United States was not as straightforward as many might think. The stark reality was that the protection of these rights often depended on where you lived. Imagine this. Two identical police encounters, same facts, same decisions, same use of force. One happens in California and the other in Texas. Before this Supreme Court ruling, the constitutional analysis of these two situations could have been entirely different. Not because the Constitution changed, but because the federal court circuit overseeing the case was different. This was not just an isolated issue, it was a widespread problem affecting millions of Americans. In California, federal courts followed the long-established totality of the circumstances approach, which required judges to evaluate the entire encounter. Why did the stop happen? How did the officers behave? Did they escalate the situation unnecessarily? Was there a safer alternative? These were the kinds of questions that mattered. In contrast, some of the most powerful federal circuits, such as the Fifth and Eighth, had adopted the moment of threat doctrine, which focused solely on the officer's perception of a threat in the final moments of an encounter. In these regions, the actions leading up to the moment of force, whether reckless, dangerous, or avoidable, were largely ignored. This geographic inconsistency was a violation of constitutional rights. The law was supposed to be the same for everyone, regardless of where they lived. Equal protection under the law should not depend on your zip code or which federal circuit court hears your case. It's time we ask ourselves, how can we allow such disparities in how our rights are protected? The Supreme Court's decision is a step towards restoring fairness. But will lower courts follow this lead? That remains to be seen. The numbers behind the moment of threat doctrine reveal a legal system deeply divided, failing to provide equal protection under the law. Between 2018 and 2023, federal appellate courts issued over 240 published opinions on this issue, and shockingly, they disagreed 60% of the time. This isn't just a matter of differing opinions. It highlights the constitutional chaos caused by this doctrine. What does this mean for ordinary citizens? It means that the same event, such as a police officer using force, could be handled differently depending on where you lived. In Texas, for example, a court might rule that excessive force was justified if the officer felt threatened in the last few seconds of the encounter, even if that threat was caused by the officer's own actions. In other regions, like California, A court would likely consider the entire sequence of events, including any reckless tactics or escalation. This inconsistency led to massive confusion and allowed the government to exploit the situation, taking different positions depending on where the case was being heard. The same Fourth Amendment rights were interpreted in vastly different ways across federal circuits, creating an unpredictable and unfair system. The consequences were real and life-altering. For those in jurisdictions applying the moment of threat doctrine, their constitutional rights could be nullified by the same government meant to protect them. These staggering statistics are a critical reminder of the need for reform and the urgent necessity of a legal framework that ensures consistent protection under the Fourth Amendment. In 2016, Ashton Barnes, a young man in Harris County, Texas, was pulled over for a minor toll violation, a simple traffic stop, or so it seemed at first. Ashton owed $645 in unpaid tolls. What should have been a straightforward citation quickly escalated into a tragic and fatal encounter. Deputy Constable Roberto Felix was the officer responsible for initiating the stop. Within 60 seconds, Felix had already drawn his weapon, a response that seemed completely out of proportion to the situation. Instead of following standard procedure and handling the minor traffic violation calmly, he chose to escalate. Less than 90 seconds into the stop, Felix made an alarming decision. He jumped onto the side of Barnes's moving vehicle. This reckless move was, according to law enforcement experts, a highly dangerous maneuver that violated basic police training. In a matter of seconds, things took a deadly turn. Felix fired 2 shots through the window of the car. Ashton Barnes, unarmed and already in the process of trying to drive away, was struck and killed in the process. The event was a senseless tragedy, a life taken over a $645 toll violation. Barnes's family sought justice, filing a lawsuit against the officer involved. However, as the case made its way through the courts, they encountered a devastating legal roadblock. The courts applied the moment of threat doctrine, which essentially meant that the courts focused only on the last few seconds of the encounter, specifically whether the officer perceived a threat in those final moments. This is where the legal system failed. The courts ignored the escalating actions of Deputy Felix, the decision to jump onto the vehicle, the disregard for de-escalation techniques, and the choice to use deadly force in a situation that could have been handled with far less danger. They were fixated only on whether Felix felt threatened at that final moment. Since he did, the court ruled that the shooting was justified, dismissing the case without ever considering the broader circumstances or the officer's recklessness. The decision was a miscarriage of justice. It raised a troubling question. How could a case like this be dismissed so easily, without a fair trial or the opportunity for a jury to weigh the facts? It was a clear example of how the moment of threat doctrine failed to account for the full sequence of events that led to the fatal shooting. This case, more than any other, exposed the deep flaws in the way courts were handling excessive force cases. It highlighted how a legal doctrine intended to protect police officers had instead created a system where accountability was virtually impossible to achieve. And it was this tragedy that eventually forced the Supreme Court to intervene. Ashton Barnes's death, though tragic, became the catalyst for a historic shift in how the courts would handle cases involving police use of force. It was a wake-up call, one that demanded action to ensure that justice was not determined by geography or by narrow, flawed interpretations of the law. This was the moment when the system was forced to confront the need for real accountability in law enforcement. The journey to this landmark decision began with a routine traffic stop, one that should have been an uneventful interaction between law enforcement and a civilian. But it quickly escalated into a tragic situation, culminating in the death of Ashton Barnes. It wasn't just about one man's death, it was about a system that had allowed injustice to persist, unchallenged, for far too long. The Supreme Court's intervention was the turning point, the moment when the highest court in the land stood up to end an era of legal confusion and inequality. The case had highlighted a glaring flaw in the application of the Fourth Amendment, the moment of threat doctrine, a legal loophole that allowed police officers to justify their actions based solely on the final seconds of an encounter. For years, this doctrine had been used in courts across the country to excuse actions that would otherwise be considered reckless or excessive. The idea was simple. If an officer perceived a threat in those final moments, their actions were deemed reasonable, no matter what had happened leading up to that moment. It created a legal environment where accountability was not just rare, it was practically impossible. In the case of Ashton Barnes, this doctrine played a pivotal role. The officer involved, Deputy Constable Roberto Felix, made a series of tactical decisions that led to the deadly outcome. Yet, under the moment of threat doctrine, those earlier decisions, such as jumping onto the moving vehicle, were dismissed as irrelevant. The court's focus was solely on the moment when the officer felt in danger, not on how the situation had escalated. This logic was not only troubling, it was dangerous. The idea that the actions of law enforcement could go unchecked because of a fleeting moment of perceived threat undermined the very foundations of justice. The Supreme Court, however, recognized the gravity of the situation. By accepting the case, the justices sent a clear message: the law must be applied uniformly and fairly, regardless of geography. The court's decision to intervene was not just about this one case. It was about restoring balance to the legal system, about ensuring that rights were protected equally for all Americans, no matter where they lived. The justices understood that the doctrine had created a dangerous precedent, one that left countless victims without recourse for the actions of law enforcement. Justice Elena Kagan, writing for the court, articulated the central issue with the moment of threat doctrine. She pointed out that this approach ignored the totality of the circumstances, the broader context in which law enforcement decisions were made. By focusing only on the final seconds of an encounter, the court noted, officers were essentially allowed to justify any action, regardless of how reckless or disproportionate it might have been earlier in the incident. This was a systemic flaw that needed to be corrected. The decision was nothing short of historic. For the first time, the Supreme Court ruled that law enforcement's actions had to be evaluated in full context, from beginning to end. The idea that an officer's conduct could be excused based on a split-second decision without considering the entire situation was no longer acceptable. This was a major step toward ensuring accountability, not just for police officers, but for the legal system as a whole. It sent a clear message. No matter the circumstances, the law must uphold the rights of every individual, and justice must be applied consistently across the nation. As the justices concluded their ruling, the legal landscape was forever changed. The moment of threat doctrine was dead, and with it, a long-standing barrier to justice had been torn down. The question now was whether lower courts would honor this decision or attempt to circumvent its spirit. What was clear, however, was that the court had made its position unmistakably clear. Context matters, and so does justice. In a groundbreaking 9-0 decision, the Supreme Court of the United States made a clear statement on police accountability under the Fourth Amendment. This case, which began with a simple traffic stop that escalated tragically, forced the court to address a crucial issue: how should law enforcement be held accountable? Before this ruling, the moment of threat doctrine allowed courts to focus only on the final seconds of a police encounter, often ignoring earlier actions that contributed to the danger. This narrow view often shielded officers from accountability. However, the court rejected this doctrine, emphasizing that justice requires a full review of the entire situation, from the initial interaction to the final moments. The decision highlights that police tactics, including failures to de-escalate, must now be part of the analysis. Excessive force cannot be justified by a threat that was created by the officer's own actions. While qualified immunity wasn't abolished, this ruling makes it much harder for officers to evade responsibility. The decision is already reshaping policies and training, making de-escalation a constitutional requirement. This ruling sends a powerful message: accountability matters, and justice must be applied equally. It will have a lasting impact on policing and law enforcement practices for years to come. The Supreme Court's landmark decision is not just about rewriting the law. It's about ensuring that justice is truly fair and equitable across the entire United States. With this historic ruling, police officers are now required to undergo new training that prioritizes de-escalation, and reckless escalation has become a legal risk. No longer can officers simply justify their use of force by focusing solely on the final moment of a threat. The ruling demands a comprehensive evaluation of the entire encounter from start to finish, ensuring that officers are accountable for every action they take. This change will have far-reaching consequences for cities across the nation. Insurance companies are already reassessing their exposure to lawsuits, and police departments are beginning to update their training manuals to reflect this shift. Local governments are reopening cases that had previously been dismissed due to the moment of threat doctrine, as this new precedent could change the outcome for many individuals who were previously denied justice. However, while the ruling is a step forward, the real test will be whether lower courts will fully embrace and apply this new standard or attempt to undermine it through narrow interpretations. Will judges continue to uphold the full context of police encounters, or will they try to slip back into old habits of granting excessive immunity to law enforcement? That remains to be seen, but this ruling makes one thing clear: the protection of our rights and the duty to protect them is not up for debate. This is a pivotal moment in the fight for justice, and it is now up to all of us to ensure that this decision leads to lasting change. Share this video to spread the word, and don't forget to subscribe to stay informed as this story unfolds. Justice has been delivered, but the journey is far from over.